Welcome. My name is Josh Wheeler. I'm the Associate Director of the Thomas Jefferson Center for the Protection of Free Expression here in Charlottesville, Virginia. Because one of the most effective means to protect free expression is simply to engage people in discussion and contemplation of the important role that free speech plays in American society, we at the Center are both very pleased by and honored and grateful to the Virginia Foundation for the Humanities for allowing us to collaborate with them to bring you this event this afternoon. As you all know, the Virginia Festival of the Book is an annual event which promotes literacy and celebrates books. The festival emphasizes programs both in schools and in festival venues that are, with few exceptions, free of charge. Hundreds of businesses and individuals have made in-kind and monetary donations. If you would like to join them in supporting the festival, please stop by the Virginia Book Information Desk at the Omni Hotel or mail a donation to the Virginia Foundation for the Humanities, 145 Ednam Drive, Charlottesville, Virginia, 22903. For more information on the Virginia Festival of the Book, you can consult their website or you can visit the Thomas Jefferson Center's website at www.tjcenter.org. The topic for this session is patriotism and the right of free speech and press during wartime. What does the past predict for the rights of free speech and free press during the War on Terror? As an introduction to that topic, I'd like to relate to you two items, one of which you can verify, one of which you're just going to have to trust me. The one you can verify is an Associated Press article that appeared just yesterday, and I'd like to read to you the introductory paragraph. Galvanized by the American attack on Iraq, anti-war activists around the country set off their own barrage of street protest, chaining themselves together, blocking workers in traffic, walking out of classes, and parading in mock chemical suits. Hundreds were arrested from San Francisco to Washington, D.C. But the anti-war groundswell brought out thousands of counter-demonstrators. One in Mississippi carried a sign saying, "Support the U.S. or keep your mouth shut." The other item that I would like to relate to you occurred just this morning when I took my 4-year-old daughter to a playground to play, and I was pushing her on a swing set, and a few feet away was a group of about 6 young kids, 8 to 10 years old. And I was close enough that I could overhear their conversation, which turned out to be no less than a discussion of the current events, the war in Iraq. And I was both impressed and depressed to note that these youngsters were talking about this subject when their conversation turned to what they would like to do if, in fact, they were serving in the war now. And one young man, he couldn't have been older than 9 years old, said, "I would be the captain of an aircraft carrier." Pause. Then he went on, "But there'd be no reporters on my ship." I'm not exactly sure what that means for the right of free speech and free press, but we'll address that today with our panel. I offer both of those items to you as evidence that I think one would be hard-pressed to find a timelier subject than that which we are about to address. I think one would be equally hard-pressed to find a group of panelists more distinguished than those that we have today to address that topic. On my far right, Henry Abraham, who is one of the country's most respected scholars of the United States Supreme Court. He is the James Hart Professor of Government and Foreign Affairs Emeritus at the University of Virginia, and among his many works are Justices, Presidents, and Senators, A History of Supreme Court Appointments from Washington to Clinton, History of the Judicial Process, an Introductory Analysis of the Courts of the United States, England, and France, The Judiciary, the Supreme Court and the Government Process, and Freedom in the Courts, Civil Rights and Liberties in the United States. This last work was actually a collaborative effort between Professor Abraham and our next panelist I'd like to introduce. Barbara A. Perry is the Carter Glass Professor of Government and the Director of the Center for Civic Renewal at Sweetbriar College in Sweetbriar, Virginia. In 1994 to 95, she served as a Judicial Fellow at the U.S. Supreme Court in the Office of the Administrative Assistant to the Chief Justice. She is the author of numerous articles and books on the Supreme Court, including The Supremes, Essays on the Current Justices of the Supreme Court of the United States, The Priestly Tribe, The Supreme Court's Image in the American Mind, A Representative Supreme Court, ? The Impact of Race, Religion, and Gender on Appointments, and, as I mentioned earlier, her collaboration with Professor Abraham, Freedom in the Courts, Civil Rights and Liberties in the United States. To my immediate left, Robert O'Neill, who is the director of the Thomas Jefferson Center for the Protection of Free Expression, and my boss. And he's also a professor of law at the University of Virginia School of Law. He is one of the nation's foremost authorities on the First Amendment, and he's author of a number of books on that subject, including Free Speech, Responsible Communication Under Law, The Rights of Public Employees, Classrooms in the Crossfires, Free Speech in the College Community, and his latest work, The First Amendment and Civil Liability. And our fourth and final panelist is Catherine McNamara, a writer, editor, and publisher. She is author of the book Narrow Road to the Deep North, A Journey into the Interior of Alaska, and has also written numerous essays, including Organizing a Literary Journal as the World Changed. The topic of that essay is something she knows about firsthand, as she is the editor and publisher of Archipelago, an online international quarterly of literature, the arts, and opinion, and which can be found online at www.archipelago.org. For our program today, I'm going to ask each of our panelists to make a short presentation on a different aspect of today's topic, to be followed by a question and answer period. Professor Abraham, if we could start with you, would you please provide us with some context for today's discussion by perhaps telling us some of the general principles the Supreme Court has articulated about the limits of the right of free speech, particularly during times of war?
Thank you. I know you have a clock there somewhere, so you should have stopped me. Adopted in 1791, Article 1 of our Bill of Rights, of our Constitution's First Amendment, gave the fledgling United States the hallowed freedom of expression at issue in our discussion today. Then it applied only to the national government, but it was incorporated or nationalized via the 14th Amendment, which was enacted in 1868 by decisions of the Supreme Court of the United States. Those decisions came largely in the 1920s and 1930s, and thus what that has meant really is that the Bill of Rights, which was initially only incumbent upon the national government, is now, with minor exceptions, incumbent upon the states as well. In other words, the Bill of Rights, since approximately 1925, now applies to the states. This was not done by a law, it was not done by a constitutional provision, it was done by Supreme Court decisions. It's a pretty powerful body. If we Americans have and practice ambivalence as our primary ideology, the realm of the precious freedom of expression is assuredly a case in point. The commonplace expression, "It is a free country, isn't it? So I can darn well say what I please," is in fact sincere, for its underlying philosophy is ingrained in the body politics notion of what democratic America means. But its paradox is that throughout history, we so often permit, wink at, even encourage its violation in practice. Thus, we have been quite willing to curb the dangerous, the seditious, the subversive, the prurient, the obscene, the libelous, and a host of other presumably undesirable modes and manners of expression that, at a particular time and a particular place, seem to justify repression. Yet, unless one accepts the absolutist approach advocated so consistently by Justice Black and his supporters, an approach that nonetheless still necessitates an answer to the basic question of just what expression is, the need to draw some line is primary because, as Black observed in a famous 1941 dissenting opinion, quote, "Freedom to speak and write about public questions is as important to the life of our government as is the heart of the human body. In fact, this privilege is the heart of our government. If that heart be weakened, the result is debilitation. If it be stilled, the result is death." Justice Brandeis, whose last 2 years of service on the bench of the highest court coincided with Black's first 2, tried to provide a memorable guideline when, in a concurring opinion, joined by his colleague Holmes, he defended the chance-taking aspects of freedom of expression in ringing terms. And I quote, and this is one of the most famous and most beautiful expressions by a Supreme Court justice, "Those who won our independence believed that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth, that without free speech and assembly, discussion would be futile, that with them discussion affords ordinary adequate protection against the dissemination of noxious doctrine, that the greatest menace to freedom is an inert people, that public discussion is a political duty, and that this should be a fundamental principle of the American government," end quote. He wrote this in 1927. Yet, if we regard the various choices judicial bodies have and we have, is absolutism the answer? It is not really a solution, neither in peacetime nor in wartime. Lines and limits must be drawn and are, in the final analysis, drawn by the Supreme Court of the United States. The hauntingly beautiful penmanship of Justice Robert H. Jackson is illustrative of both the necessity and the vexatiousness of those lines and limits. Thus, in 1943, that was wartime, as many of you will remember, he authored the court's 6-3 opinion in West Virginia Board of Education versus Barnett, striking down West Virginia's compulsory flag salute in a suit brought by Jehovah's Witnesses. He noted in that wonderful majority opinion, and I quote, "Those who begin coercive elimination of dissent will soon find themselves eliminating dissenters. Compulsory unification of opinion achieves only the unanimity of the graveyard," end quote. Yet that same Justice Jackson, after his assignment to the war crimes trials in Nuremberg in 1945, would caution his colleagues, and in dissenting from the court's 5-4 refusal to crack down on professional native fascist rabble in causing a riot in Chicago. He, in that famous case called Terminiello versus Chicago, cautioned, and I quote, "There is danger that if the court does not temper its doctrinaire logic with a little practical wisdom, it will convert the Constitutional Bill of Rights into a suicide pact." You have here the two opposites, and you also see that lines have to be drawn and how difficult it is to be drawn. We do not, even in wartime, have to commit suicide, do we? We do not, even in wartime, make it impossible for people to speak their minds. Now, the difficulty of any attempt to establish viable standards in the realm of freedom of expression is, of course, apparent. Yet attempts to create judicial tests, doctrines, or formulae have been of lasting concern to the court and the country. Much depends on the definition of terms which determine a particular judicial decision. But in addition to the self-evident one of balancing competing interests, several judicial line formulae or major judicial tests, all of them post-World War I phenomena, have been established by the United States Supreme Court, as my colleague Barbara Perry will outline with her customary clarity. They are in chronological order. 1, the clear and present danger test. The question here is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. The second test, the bad tendency test, whether the defendant's specific utterance has a natural tendency and probable effect to bring about the substantive evil which the legislative body might prevent. That is a much milder test. The clear and present danger test is a more generous test. 3, the balancing test. where First Amendment rights are asserted to bar governmental action, resolution of the issue always involves balancing by the courts of the competing private and public interests at stake in the particular circumstances shown. 4, there is the absolute test, which I've alluded before, and I quote from one of the authors of that test: "It is my belief that there are absolutes in our Bill of Rights, and that they were put there on purpose by men who knew what words meant and meant their prohibitions to be absolutes." To that you can join a literal assault or a literal comprehension of the verbiage of the Constitution. Number 5, there is something called the speech conduct test, which takes into account the time, place, and manner. Quote, "While I have always believed that under the First and 14th Amendments, neither the state nor the federal government has any authority to regulate or censor the content of speech, I have never believed that any person has a right to give speeches or engage in demonstrations where he pleases and when he pleases." And finally, there is the mere advocacy test. The Constitution guarantees of free speech and free press do not permit a state to forbid or proscribe advocacy of the use of force or of law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. And mind the adjective imminent. It is a very crucial element in this particular test. These 6 tests provide the courts with a choice. You will hear, I think, or you will see the identification of the test which we're using at the present time. In any event, no matter which test one goes to, no matter how you reflect upon this crucial issue, it is a highly significant one, how to draw the line. How to draw that line is a very, very difficult and delicate task, and it is also a vexatious task. We should draw it generously. We usually have drawn it generously, even in wartime. We do not, however, have to commit suicide in the process. Thank you very much.
Thank you, Professor Abraham. Barbara, could you, as Professor Abraham indicated, the difficulty of drawing the line, the devil's in the details. What has the Supreme Court specifically said may or may not be done by those who oppose a war to express their opposition to the war?
Right. Well, what I'd like to do in answering Josh's question and following up to Henry's comments is to point out some of the cases in which these tests Henry has just outlined so clearly were delineated by the U.S. Supreme Court. Obviously, we are a country born of war, born of dissent, born of revolution, in fact. I'm going to focus, however, on the 20th century wars, and heaven knows we had enough of them in the 20th century. But I'm doing that for a couple of reasons, one related to the point that Henry raised, that the First Amendment's protection of freedom of speech and freedom of the press were actually applied from the U.S. Bill of Rights to the states in the 1920s and 30s. In addition to that, the U.S. Supreme Court in the early 20th century also declared that freedom of speech and freedom of press were the so-called preferred rights, that is, rights that had a higher plane of protection in the United States. I want to begin with a quotation not from a U.S. Supreme Court justice, although his father, Tom Clark, was a U.S. Supreme Court justice. Ramsey Clark, who's been in the press recently as a member of the peace movement, said, as U.S. Attorney General, "Liberty will keep her head down when she is being shot at, like everyone else." As it turns out, the U.S. Supreme Court has a mixed record on this point. Sometimes the Supreme Court has kept its head down along with liberty. Sometimes it has very courageously raised itself up above. And in two wars, World War I, and I'm including the Cold War in this as well as part of 20th century warfare, the U.S. Supreme Court actually decided against individuals and in favor of government security. Henry was indicating that vexatious line, where to draw the line between individual rights of dissent and also protection of national security. So in several cases I'll just mention briefly, the U.S. Supreme Court ruled against a socialist and ruled against communist dissenters and sympathizers. In a case that came down from the court just after World War I had ended but came about because of World War I, the question was raised, should a member of the Socialist Party be allowed to print and circulate to men who had been drafted and accepted for military service a document to cause insubordination in the armed forces and obstruction of recruitment and enlistment in violation of the Espionage Act of 1917. The court answered, no, a socialist should not be allowed to do this, and in fact, this particular socialist was in violation of the Espionage Act of 1917. And it is in that case, the Schenck case, that the court develops the very famous clear and present danger test, which Professor Abraham mentioned. Moving on to the Cold War then, two cases. Can a professor refuse to answer questions concerning alleged communist infiltration into the field of education put to him by the House, the infamous House Committee on Un-American Activities? The professor's argument was that on the grounds that these questions infringed his rights protected by the First Amendment. The court said no, the professor could not decline to answer these questions put to him by a duly authorized committee of the U.S. Congress. And in this instance, the court developed its so-called balancing test and just came right out and said, we don't believe in absolutes, or the majority didn't in that case. Instead, we have to balance between individual rights and national security, and during the Cold War, the court sided with national security, as it did in a second case from that era, this involving the Smith Act from 1940. The Smith Act made it unlawful for any person to, and it split its infinitive, so pardon me on the grammar, but to knowingly or willfully advocate, abet, advise, or teach the duty, necessity, desirability, or propriety of overthrowing or destroying any government in the United States by force or violence. Is that law unconstitutional or constitutional under the First Amendment? The court said it was constitutional, and in its famous majority opinion via the Chief Justice in that instance, the court noted that the government, again to protect itself, does not have to wait until the coup is underway. Or about to be underway. But prior to that, those who are advocating the coup or overthrow of the government, in this instance, 11 top-ranking members of the Communist Party. Let me move on then to the Vietnam era. And perhaps to the surprise of some, the court at that time, but perhaps not to the surprise of others, when we think about that court in the period of the 1960s as being probably its most civil libertarian as ever, the court primarily during the Vietnam era was in favor of free speech and the press, perhaps reflecting the very controversy over that conflict. But the first case I'm going to mention today is one of burning a draft card. In this instance, could an individual burn a draft card on the steps of the South Boston courthouse, arguing, as he did, that it was a bona fide manifestation of freedom of expression? The court said no. This was one instance during the Vietnam War where they did not uphold this dissent, this protest. And can you believe it was Chief Justice Earl Warren who wrote the majority opinion against this individual? But he pointed to a 1965 amendment to the Draft Act which specifically made it unlawful to burn or to destroy any kind of draft certificate or certification. Now, to move on, though, to the cases in which the court in the Vietnam era did uphold dissent or did uphold the right of free speech or free press. The next case is the wearing of a jacket with the words. Now, I'm not going to actually say the word. It's the infamous F word, because C-SPAN is a family television station, and my family's watching. Mother, don't worry, I'm not going to say it. F, ... the draft. Henry always likes to point out in his constitutional law classes that that declaration is an anatomical impossibility, so we might keep that in mind. Nevertheless, this young man walked into the Los Angeles County Courthouse with F the draft emblazoned on his jacket, making the argument that this was constitutionally permitted speech. The court agreed with him. Yes, indeed it was. They said that it was not exactly pure speech, but it was closer to pure speech than not, that there was no incitement, no imminence to lawless action there, or even action that was anatomically possible. It was not fighting words, they said. It was not obscene. They agreed it might be vulgar, it might be a vulgarity, but they made the famous statement that one man's vulgarity is another man's lyric. Moving along, Can junior and senior high school students to protest the Vietnam War at this time, can they wear black armbands to school? Schools said no. They were sent home, violation of disciplinary code. The court ruled with them in 1969. Yes, they could, because again, even though it wasn't pure speech, it was a symbolic form of speech. The majority did not see it as conduct, but at least symbolic speech that was protected by the First Amendment. And in the very eloquent words of Justice Abe Fortas, who wrote the majority opinion in that case, students and teachers do not shed their constitutional rights at the schoolhouse gate. Very much related to what we're seeing in terms of what Josh related to us at the beginning of today's program, is a conviction during the Vietnam War under a state of Washington, state flag desecration law of a man who had put a peace symbol on his flag to protest invasion of Cambodia and the tragedy at Kent State. Was that a violation of his First Amendment rights? Yes, the court said. This was, again, an instance of symbolic speech. It was his private flag on his private property. And then the very, very important case involving the press, the Pentagon Papers case, and I think Bob may make some reference to this a little bit later, but could the government say to the Washington Post and the New York Times, you may not publish the Pentagon Papers? These were top secret papers that had been turned over to the newspapers by Daniel Ellsberg. They delineated the history of the United States in Vietnam. The court upheld the publication of those papers, saying to do otherwise would be unconstitutional prior restraint. Just to end then, to talk a little bit about the Persian Gulf War. That war, thank goodness, lasted so briefly that no cases came to the U.S. Supreme Court because it was over by the time those cases would have made their way through the judicial process. But there were two questions that were presented to lower federal courts at that time. First, may the government bar the press from the Dover Air Force Base, which was the receiving point for the American war dead in that war? A U.S. District Court, in fact, said yes, that the military could create this rule because a military base is not a public place, and the rules were reasonable even under freedom of press as protected under the First Amendment. The final question, may the government require reporters to file war zone stories only from Pentagon-organized press pools, as the Pentagon did during the Persian Gulf crisis? And that, again, the war ended before the court was able to answer the question. Relates directly to what Josh began with today, although the discussion began on the playground, but the little boy saying, I'll be captain of the ship and there won't be any journalists with me. As we all know from the last few days, we've seen just incredible pictures, photographs, somewhat grainy sometimes if they're done by satellite phones, but the Pentagon has obviously done a complete turnaround on its press relations by allowing journalists to be embedded into military units and on ships. So with that, I will pause and turn the program back to Josh.
Thank you, Barbara. Bob, I'd like to ask you to pick up where Barbara left off, or the natural evolution of this conversation, which is we've been discussing the rights of free speech and free press during times of war. The First Amendment doesn't make any distinction in terms of times of war, times of peace. Should the rights of free speech and free press be constant, or should the contours of those rights adjust depending upon whether we are in a state of war or in a state of peace?
Josh, I've decided that the critical answer to all these issues depends on whether that young man you overheard this morning grows up to be a naval commander or a journalist. When we can predict that with confidence, we'll know the answers to all the other questions. There is an ancient Latin maxim which, like most maxims, oversimplifies a very complex truth. It is simply stated, inter armas leges silent. Most of you, I suspect, can translate the Latin, so let me paraphrase very freely. Once the bombs start falling, forget about the Bill of Rights. How accurate is that maxim as a way of characterizing this constant tension as we move from a time of relative peace to a time of international conflict? Let me illustrate in terms of three issues, three questions to which one would assume the answer was a lot clearer than it turns out to be. The first has to do with freedom to advocate an unpopular cause. The second freedom to publish or to speak without prior restraint, and the third, freedom to publish sensitive but potentially damaging information which the government would strongly prefer not be published. Let's take first the issue of advocacy. Henry Abraham gave you the essence of that 1969 decision, in which the Supreme Court declared what has been ever since the guiding standard with respect to advocacy, that you can't punish a speaker unless what is said amounts to a direct incitement to imminent lawless action with a high probability that such action will occur. The problem with relying too heavily on that principle today is that the case involved a Ku Klux Klan rally and a racist organizer in a field in southwest Ohio. In other words, it was quite remote, even though it happened during the Vietnam conflict. It was completely remote from any issues of national security. Mr. Brandenburg, the Klan leader, actually was what Justice Jackson, in another of his memorable opinions, characterized as a street corner hothead, and as to whom Justice Jackson said, we can tolerate all sorts of outrageous speech coming from a street corner hothead that we could not tolerate coming from someone who is organizing a conspiracy bent on undermining or destroying the government of the United States. Well, virtually all our cases for the last third of a century and more have essentially involved speech by street corner hotheads. We're now about to see how far the street corner hothead, or the Brandenburg case principle, applies in much more stressful, much tenser situations. There is already some indication that the Justice Department believes that in time of great international tension, that test is not the ultimate limit. For example, the indictment several months ago of 6 U.S. citizens of Yemeni ancestry in Lackawanna, New York, did not involve evidence of the kind that would meet the Brandenburg test. It involved evidence that they had participated in al-Qaeda meetings and had attended al-Qaeda camps, had been indoctrinated by and apparently had indoctrinated others in al-Qaeda principles. Now, so far, we don't have anything that sounds much like direct incitement of imminent lawless action. Whether the Justice Department is correct in believing that in times like these, a court would convict and reviewing courts would uphold a conviction on such facts, that's the critical issue. Let me move then to the second question, freedom from prior restraint. It's a basic truth in First Amendment law. The one thing we abhor in this country, we learned our lesson during the colonial period by watching prior restraints and gags and so on in British law. So the lesson, one of the lessons that we learned is that a prior restraint preventing publication is simply incompatible with our commitment to free speech and free press. The cases in which that maxim has been applied, one was involving a racist newspaper in Minneapolis in 1931, and then, of course, as both Henry and Barbara have mentioned, the Pentagon Papers case in 1971. Now, you may say the Pentagon Papers case did arise in a wartime context, but the strongest claim the Justice Department could make in trying to shut down the New York Times and the Washington Post in publishing the Pentagon Papers series, the strongest claim they could make is that if all this did appear in print, it might embarrass the United States in our relationships with friendly Southeast Asian nations. That clearly was not of the order of magnitude that might warrant the intervention of a court. Indeed, Justice Brennan, for whom I served as a law clerk exactly 40 years ago this year, in his concurring opinion, Justice Brennan said, now it would be different if we were dealing, this is his specific example, with someone publishing the itinerary of a troop ship already at sea in time of war. That, he said, might be a situation in which a prior restraint or an injunction would be warranted. So, are we now approaching a time when such terribly sensitive information might be about to be published and a court might be asked to enjoin it? Take yourself back just a week or so. Suppose a major news medium had obtained a very detailed plan for an attack on Iraq and was about to publish it. And the Justice Department had gone to a judge. What you typically do is find some judge who's known to be sympathetic. You get that judge out of bed at 3 in the morning. And one thing about a judge, you don't need a courtroom, you don't need a bailiff, you don't need a black robe or a gavel. A judge has the authority of the office at any time round the clock and wherever the judge happens to be. You ask that judge to enjoin publication. My sense is that virtually any judge, liberal, conservative, or in between, under those circumstances would have said, hey, this is like the itinerary of the troop ship already at sea in time of war, and I am going to prevent the New York Times or the Washington Post or NBC or CBS or C-SPAN. I'm going to prevent them from publishing this information because this is a different situation from the kind of cases we've dealt with in the past. The third area is more complex. We know even less about it, and that's freedom to publish sensitive information that government would rather, very much rather, did not come out. In the Pentagon Papers case, a majority of the justices did seem to agree that if this issue had come up after publication, there were acts of Congress on which criminal charges could have been based, and those criminal charges probably would have been consistent or compatible with the First Amendment. Well, obviously, after losing the case to enjoin publication, the Justice Department didn't simply turn around, go back to court, and bring a criminal prosecution against the Post and the Times and Neil Sheehan. Had they done so, an issue that media lawyers wonder about all the time, had that happened, there's at least a pretty good probability that a conviction could have been obtained, and that while several justices would now have dissented, a majority of the Supreme Court probably would have upheld that conviction, saying, oh, sanctions after the fact, even where the risk was only embarrassing our relations with Southeast Asian nations, if that's clearly what Congress prescribed, and Congress has done so, then that would be okay. Not only has Congress done so, but a few months ago, Attorney General Ashcroft, to the amazement of many observers, said he did not think new laws were needed for that purpose, that the existing statutes, the ones that were cited back in the Pentagon Papers case, those were probably adequate to whatever needs might arise in the future. Well, all these questions remain to be tested. And in short, we know a lot about free speech in fairly normal times, even times like the Vietnam War. What we don't really know is how durable those principles fashioned in easier times than these, how durable those principles are going to prove when they're really put to the critical test in much more stressful times in which we now seem to be entering and into which in the months ahead we may progress far more deeply. So these are more questions than answers in a sense, but trying to give just a prospect of what's out there.
But I'd like to now take all of this and apply it to today, and ask Catherine McNamara, Catherine, if, as the Bush administration claims, and I think understandably so, we are in a new era with a different kind of war, then which of these precedents should we follow?
It's a very good question. This week, I've been saying to myself, so this is what it's like to be a citizen of the empire. Since the President's speech of September 2002, we have known he meant to prosecute a new kind of war for America, that is, except for the Indian Wars. When he announced the doctrine of first strike, a preventive war against any possible threat to this nation's enlightened domination of the world, in the words of the New York Times. Now this nation is at war, in search of, intending to destroy the power of three men, Saddam Hussein and his two sons, and the cohort protecting their despotic regime. I hope to God the fulfillment of that aim will result in the fewest possible deaths on all sides. The President has said that this homeland of ours, too, is now a battlefield because of the September attacks. In fact, I learned that journalists, or at least the Pentagon, now refer to the battle space because of such changes as satellite uplinks and 24-hour news cycle. My ear on the battle space has been, for the most part, the respectful attention given it by NPR's special coverage. But on Thursday, I listened to CBC and heard an interview with a Liberal MP, Mr. John Godfrey. He was asked about Canada's position on the war, which has been to stay at a distance, and whether Canada should threaten the U.S. more boldly. Mr. Godfrey replied, I believe I quote him accurately, "A redefinition of America is going on. We should wait for it to settle down. Don't provoke or go too close." A redefinition of America. Let us see ourselves as others see us. This country seems to me as divided as before the Civil War. The matters at issue now are not bondage and civil war, however, but what kind of nation we have become, how we should conduct ourselves in the world and treat our people at home. What ought our country to do with its power? It has unleashed its might to provoke shock and awe over Baghdad. But we had already known shock and awe here on September 11th. Is this now to be the nature of war? In this new kind of war, in this battle space, where do we find precedents for the right of free speech? Have our basic rights changed as we have become, and has been proudly and definitely said, an empire? I see war, then, as an instrument of politics, and I propose that not only this ground and air war against Iraq, but also the so-called war on terror, be understood as part of this redefinition of America. I don't believe that we have settled on it yet, though. I believe, perhaps desperately, perhaps defiantly, that the political process is still in operation and that empire may not become a permanent condition. Once the war on Iraq is over, but when will we know? Once the war is over, will we return to the continued metaphor of war on terror? In that state, the military has become used as the prime instrument of American power to carry out everything from foreign affairs to humanitarian relief. Dana Priest of the Washington Post writes, "When the fighting stops in Iraq, the U.S. military, 22-year-old infantry soldiers, will again be given the lead in rebuilding civil society there, a mission that could easily take more than 10 years. It is the military which now imposes our national will, or that of our president. Will this continue with the consent of the governed? An extension of military dominance is the Missile Defense Program, which is to be operational within 2 years, according to the order of the President. Ostensibly, it is for our protection against rogue states like North Korea. Equally important, though, it is meant to achieve the weaponization of space dominated by this enlightened nation. And our domestic security is to be secured by ever-growing secrecy of government, restriction of information, hiding of documents from public view, including increasing the difficulty of FOIA searches, Freedom of Information Act searches, classification of documents, and extending the length of time documents are left classified from public knowledge. I'll read you, in fact, a headline from the paper yesterday. U.S. ready to rescind Clinton order on government secrets. Washington, March 20. Making it easier for government agencies to keep documents secret, the Bush administration plans to revoke an order issued by President Bill Clinton that, among other provisions, said information should not be classified if there was, quote unquote, significant doubt as to whether its release would damage national security. You can find this in the March 21 issue of the New York Times. Are we to live, then, in a permanent state of war? Have we, the governed, consent to this? Who benefits from this? As a publisher, I'm going to be watching on a number of fronts. Let me give some examples of stories I'm following. Not as a publisher, as an interested citizen. 1, the USA Patriot Act. You may read Senator Russ Feingold's lone voice of objection to the passage of that nefarious act, in fact, on Archipelago. I will be interested in the progress of H.R. 1157, the Freedom to Read Protection Act, introduced on March 6th of this year, which allows some slightly increased protection against the FBI, which, under the Patriot Act, is allowed to search bookstore and library records with a warrant obtained from the secret FISA court without even the need, I'm quoting now, I'm quoting from a letter from Pat Schroeder, the director, the president of the American Association of Publishers. A warrant obtained from the secret FISA court without even the need to show probable cause of criminal activity or an individual's connection to a foreign power. Librarians and booksellers cannot reveal the fact that such a warrant exists, and so they cannot defend their right to disseminate and the right of their patrons to receive constitutionally protected materials. Given the very troubling provisions of the Patriot Act, this is the least of it. The Foreign Intelligence Surveillance Act of 1978 was passed after the excesses of federal spying on domestic political groups in the years of the Vietnam War and Civil Rights Movement. The primary purpose of FISA was to gather counterintelligence information, I'm quoting now from an article, which is also reprinted in Archipelago in part. The primary purpose of FISA was to gather counterintelligence information, not to make criminal prosecutions. Surveillance would be conducted under the guidance of the Justice Department, employing a team of lawyers to work with the Attorney General and the FBI. An innovation proposed by then Attorney General Griffin Bell created a special court of sitting federal judges who would approve FISA wiretaps the same way judges approve criminal wiretaps. For the following 24 years, the FBI, close quote, the FBI got its approval of secret wiretaps, perhaps 10,000. In fact, Senator Kennedy said originally they thought it might be a few hundred, but it's been about 10,000, I read. Until last May, when the FISA court, for the first time apparently, refused Ashcroft's request for a phone tap, saying the court saying the FBI evidence was defective. We didn't even learn about this publicly till August of last year, when the Post published a story about it. The Patriot Act decreases to the point of nearly eliminating, I understand, the old Fourth Amendment protections in criminal investigations, allowing the less stringent presumption of intelligence to be used in investigation of American citizens. I will also watch as an increasing number of municipalities take a public stand against the Patriot Act, or they had been. Will that change now? Let us see. 2, language. This morning, for example, NPR had a nice explanation of the word coalition, used by the Pentagon to refer to the 40-odd nations who have publicly agreed to be associated with this war. In fact, says NPR, only 3 nations have supplied troops: America, Britain, and Australia. Sadly, so far, the greater number of casualties among these armies has been sustained by Britain. But when we hear the word coalition, we ought to know exactly what it means in practice as opposed to what it is implied to mean. 3, propaganda, the underbelly of language. We have many sources of direct, reliable information now because of the internet and the World Wide Web. Regularly, I read or listen to The Times, The Post, Haaretz, the International Herald Tribune, the CBC, BBC World Service, and other sources. I read blogs, weblogs. A very fine one is run by Helena Cobbin at, I hope I have this right, and if she's here, she'll correct me, I hope, www.justworldnews, all one word, .org. I receive and send information and opinion by email. If I remain eternally vigilant, I may be numbered among those citizens who continue to secure our liberty. But let me note how vigilant we must remain with one not untypical example from a briefing by Ari Fleischer on March 20th. This is a quote from the New York Times article reporting this. Quote, Mr. Fleischer disputed the view of Europeans and others who argued that the pending invasion is a violation of the United Nations Charter. He cited 3 Security Council resolutions that he said provided all of the authorization Mr. Bush needed. But he also likened the current preparations to the Cuban Missile Crisis in 1962, arguing that just as President John F. Kennedy imposed a quarantine around Cuba, an act of war, said Mr. Fleischer said, to force Havana to remove nuclear missiles, Mr. Bush is acting to protect the United States from a threat that it would never see coming, close quote. I do not know if the assembled reporters gasped at the untruth of Mr. Fleischer's statement. I gasp at it and correct him. A quarantine is specifically not an act of war. That is why Mr. Kennedy did not impose a blockade, which is an act of war. 3, how the post-war of stories I will be following. How the post-war reconstruction is managed in Iraq, particularly as to the contracts already let to Halliburton, Bechtel, and other transnational corporations. That the vice president came to office from Halliburton I would have thought, raised questions, at least, about conflict of interest in the letting of these contracts, as has been done already. Further questions would be whether politically the U.S. should continue its unilateral actions in this regard. This is related directly and indirectly to our energy policies as well, because of the roles these companies play in oil development. A few other questions. Who is responsible for bugging the EU headquarters, the European Union headquarters, especially the offices of the French and German representatives and of other nations? This was revealed several days ago, but no responsible party has been found or at least known, or at least named. I will follow this story. And 5, how the Air Force reports on the recurring incidents of rape of young women at the academy and the recurring non-prosecution of culprits. And last here, but most important, how will our political speech be limited? Our genius as a nation is that we are a secular polity formed by a marvelous constitution in which the ever larger inclusion of citizenship has been fought for and won over the last 225 years. Our civil rights, too, have been fought for and won. Are they permanent, however? Although he denied having done so, Robert McNamara had commissioned the writing of a secret history of the Vietnam War. Are secret histories being written now, I wonder? Have they been written? And will the administration's doctrine of secrecy require another Daniel Ellsberg to bring them to light? But so much of what lies before us is not secret. A single party now controls the 3 branches of the federal government. Its present leaders have never disguised their desire for power and its unlimited use for the benefit of their supporters, nor concealed their belief in their right to power. We who are ordinary citizens stand and watch our civil rights taken away by Congress. And we do nothing, for our protests are scattered and therefore useless. We are told we are not listened to unless we have sought and won the political power which will allow us to act. I have a great deal more here to say, but I'm going to let questions be asked, because there is a very great deal about what our government is doing right now to interrupt our rights. Let me end by saying this. The Israeli journalist Amira Haas, the daughter of European Jews who escaped the Holocaust and found refuge in Palestine, now reports from Ramallah. Her colleague Robert Fisk writes about her. And quotes her, saying, "There is a misconception that journalists can be objective. Palestinians tell me I'm objective," says Amira Haas. "I think this is important because I'm an Israeli. But being fair and being objective are not the same thing. What journalism is really about, it's to monitor power and the centers of power." I am not a journalist, but I think she is right.
Thank you, Catherine. I think one can take from Catherine's comments, and it's obvious if you read the papers and look around, that there's a great deal of debate going on in this country now as to the propriety of some of the current administration's actions. And I say that as a statement of fact, not as a statement of supporting one side of that argument or the other. We are in the process of a great debate about that, and we may agree or disagree with the current administration's policies. But that leads to a question I'd like all of the panelists to perhaps address, and it was raised in that earlier article that I read to you today, in which a man was quoted saying, "Support the U.S. or keep your mouth shut." And what I'd like to ask all of our panelists to address is, there are many who've expressed the view that the lack of support for the war is a lack of support for the American troops fighting that war. That leads to my question, which is public dissent of the war unpatriotic? Henry, would you like to address that first?
Public dissent?
Is public dissent
Unpatriotic.
It's not unpatriotic as long as it's within certain bounds. We have been very faithful, I think, in this country to the principles and priorities of freedom of expression. I think our record is good. I am much more optimistic than the last speaker about the standards of our public policy, about the responses, and about the legislation that was passed. I think in listening to some of the criticisms, it seems to me that some people have forgotten 9/11. And I think it would merely add that, of course, everyone has a right to speak out. Our record on the First Amendment, by and large, is excellent. Freedom of speech is probably the one area in our Bill of Rights to which everyone would point as the most desirable component. That was certainly true during all the war times that I have been either read about or been part of. So it seems to me that the alarmist view, while healthy, I suppose, that somehow the stifling of reaction is really not justified. I think we're doing the best we can. Without taking any stand on the Patriots Act, let me point out it was passed overwhelmingly by both branches of Congress. And one of which branches is very, very closely divided. There are certain other statutes which have been on the books for a long time. In short, I at least have enough confidence in the performance of our elected individuals and the appointed individuals who've been appointed by the elected ones. So it seems to me there's really no difficulty about speaking out, but there is a certain mode, a certain kind of, shall we call it, behavior which one ought to respect. For example, I just read in this morning's paper that an American flag which was posted by a citizen of Richmond, Virginia, in the council chambers, had been removed. He was an employee. He was removed, and at the beck and call of 3 members of the administration, which were not qualified. Is it a crime now to display the American flag? Do we have to trample it? Incidentally, if anyone wants to trample it, I suppose you would be privileged to do so. The Supreme Court held 7-2 not so long ago that burning the American flag is an expression of freedom of expression. And the person who wrote the opinion was Justice Scalia, who is normally assaulted as being a grim creature of the extreme right. We allow a great deal of public policy, of public comment, and I think that the question you pose would have to be answered. Almost anyone can say almost anything, short of, shall we say, advocating imminent revolutionary attitudes, not only attitudes, but actions. There has to be action. The danger has to be imminent. It cannot be theoretical. And I think a lot of the fears that I've heard expressed and displayed are very much in the realm of theory. There's nothing wrong with that, of course. Prudence is obviously the better part of wisdom in many ways. But I, for one, have enough faith in our government and in the structure of our government and in the public's attention and the public's intelligence quotient to think that to become as alarmist as we're often asked to become these days does not really give us the kind of public response that we should have. Thank you.
Bob, would you like to address the issue?
Yeah, the short answer is no, and I think the longer answer is also no, but I would alter the question a bit and ask what kinds of things that those of us who were involved in the anti-war movement during Vietnam did that we might not do today and that we might have second thoughts about. I'll give you one about which I have no second thoughts. I ended up being the person to testify before the California legislative committees in support of a bill which would have put the state of California on the map like the Commonwealth of Massachusetts as a proper party to challenge the constitutionality of the Vietnam War. I think that was entirely appropriate. I also represented 3 of my students before the Federal Court of Appeals. They happened to be reservists in good standing who had already served in the military, questioning the government's right to call them up again and send them to Vietnam. However, as I look back, I'm not sure this was unpatriotic, but I do think the way in which we disparaged our troops, those who were only sent, and remember, they didn't enlist. Most of the people who were sent to Vietnam were drafted. So as I think back, it seems to me unconscionable that many of us, and I certainly count myself among them, were so unsympathetic to the plight of those who were sent to carry out a policy which they may have thought as unwise as we thought it. Somehow I have a sense that we're better equipped today to differentiate between the policy of the government, which many of us do question, and we should feel completely free to oppose as vocally and as often and as loudly as we feel so disposed, on the one hand, and those who are simply carrying out that policy under orders with very little choice. That's the part of Vietnam that I wish in some sense we could replay. I'm not sure what we did back then was unpatriotic, but in retrospect, I think it was unfair, indeed unconscionable, and I am somewhat consoled by a sense that we've sorted out those issues a good bit better in the current conflict.
Can I add a word about that? In a sense, I was at a conference that the Thomas Jefferson Center sponsored in Washington, a very interesting day, which the topic was the media and reporting in the coming war, with the opposing right of security as the second part of that question. The topic at that moment was the Pentagon's offer to a number of several hundred journalists at their own choice to go through a kind of training in the new style of war, to see what it looked like up close, to then become, as they said, embedded with troops as they went overseas, so that there could be reporting from the source with not so much censorship, they said, as looking at the moment to see what was appropriate. That day, it had been announced, the day of this conference, it had been announced that CNN and Al Jazeera had just made an agreement of some sort for the reporting of the coming war. And the Pentagon spokesman, or someone, said that in fact Al Jazeera correspondents had taken the military training preparatory to embedding. And the reporter who mentioned this said that takes the question of patriotism out, throws it out the window. Because if they can get the same training we can they report, will they accept the limitations of reporting? Do we push at the limitations of reporting? It changes the questions right away. I would also like to say that I cannot accept the notion that any of us is not a patriot. But we have very different visions of how this country ought to settle into its redefinition.
Let's turn to free press for a second, which is obviously a related issue, but one I'd like to ask all of our panelists, or any of our panelists who'd like to address it. Should the role of the press in the United States change according to whether we're at war or at peace? In other words, what should be the role of the American press during times of war? Barbara, would you like to?
Well, I think that we can use the same dichotomy that Bob mentioned, and if he hadn't mentioned it, I would have, and that is the dichotomy between criticism of government policy and criticisms of troops who, as we are sitting here in this nice, comfortable chamber today, are facing imminent death as a possibility. So I would say that we wouldn't want to view a press that was critical of government as being unpatriotic either. And I'll go to the Pentagon Papers case, go back to that case from 1971, and note from Justice Hugo Black's opinion in that case. He said, the Founding Fathers gave the press an essential role in our democracy. That is to serve the governed, not the government. And this is a direct quote. The press was protected so that it could bear the secrets of government and inform the people. Only a free and unrestrained press can effectively expose deception in government. And again, with perhaps drawing the line that we don't want troops to be put in danger by press reporting, again, to have the dichotomy between that and criticizing governmental policy, I think is perfectly valid. So I would hold to the Hugo Black line in that instance.
Can I add, too, according to the, as I understand it, according to the embedding rules, the correspondents have signed agreements not to reveal anything they are asked not to reveal, so that so far that seems to be a very hypothetical kind of question. Of course, we don't know what will happen, but so far the correspondents, even while, or at least the ones I've listened to, even while keeping their fabled skepticism at high alert, are certainly aware that because of this situation, they're willing to go along with the governing rules.
There is, however, a big difference, Catherine, between what reporters embedded in these units have agreed to and your very accurate description of Section 215 of the Patriot Act, which prevents you from reporting or telling anyone what you have been told to release. If journalists embedded had had to agree that they would not identify what's off limits, then we'd have real problems. I must say I've been struck by the candor of reporters in saying, now I can't tell you exactly where we are, and I can't tell you where we're going tomorrow, but I can tell you where we've been, and I can tell you lots of other things. And for example, about a week ago, a Washington Post reporter was interviewed by NPR and reported at some length that he'd talked with troops who were quite dispirited because some of them had been there during the Gulf War and had said, back then we had lots of allies. Today, we seem to be alone. Nobody else is with us, except maybe for the British. And he reported, they are discouraged. Well, I thought that was a wonderful test of what can be reported. So apparently the constraints apply largely to tactics and maneuvers, military operations, and do not, in the sense that they have often in the past, apply to such subtler but terribly important issues as morale. There are, however, two risks, of which I hope the major media are aware. One is that by being given all this information, in a sense, they become unwitting promoters of the military. They're sort of hyping the market for the military interests. That's a risk. The other is that in these early days, the U.S. media, to which we know the leadership of Iraq pays close attention, I'm sure they watch CNN just as closely as they watch Al Jazeera, that so much emphasis on the might and power of the U.S. Armed Forces in these early days may be in some way designed to weaken their resistance and to force them to capitulate somewhat sooner than they might otherwise. Now, is that misusing the U.S. media? I don't know. That's a tough issue, but at least there is reason to be cautious. And since media executives are among the most skeptical, suspicious people in the world, I don't think there's much risk that they're going to be conned or that anything will be put over on them. But there are two risks in being as open and having access to as much information as they do and using it as freely.
Well, a related question regarding the press, but a very specific one. And then after this, I'm going to open it up to any questions from the audience. So be prepared to jump up if you have something burning that you want to ask. But the Supreme Court, and Henry, I'll address this to you, and then perhaps the rest of the panelists might address this issue. The Supreme Court had determined in a prior case, landmark case, that the public and press access to the courtroom, to criminal trials specifically, but implied to civil trials as well, is a First Amendment right. The current administration, however, has determined that because of during this war on terror, that access to deportation hearings of people who have some possible relation to terrorism are closed to the public and to the press. And I would ask your opinion on how whether you believe that position is consistent or with the Richmond newspaper, the dictates of the Richmond newspaper's case, and whether you think that it will ultimately be upheld, because there currently is a split in the Court of Appeals between the Sixth and the Third Circuit on that very issue. One saying that no, you can't close these hearings, you have to make that decision on a case-by-case basis, and the others accepting the government's claim that no, for security reasons, we need to keep all these hearings closed.
Well, I cannot predict what the court will do. The greatest game around the chambers of the Supreme Court is to predict how they will hand down a case, and of course that's impossible. We're usually wrong. This is a new ball game in terms of the national and international threat. The court has not had to face it in quite the fashion in which you're putting the dichotomy. It may well face it. I cannot say what position it would take. I can say that the circumstances of the terror which we have seen and which we have experienced may conceivably justify the kind of actions which have been propounded and which are embedded in at least some aspects of the legislation that we have. What the court will do, I cannot tell, but the court's record in First Amendment cases is excellent. I noticed again just recently, a few days ago, Justice Scalia won an award from a very liberal organization for supporting and sustaining the First Amendment, you see. In general, the press has had a pretty free ride by the court. Our press is the freest in the world, with possible exceptions. The British press may be equal in the Scandinavian press. I still think I'm in a movie theater sometimes when I see the reports by reporters from the ships. We have reporters assigned to each ship of any major importance. The press has done what it has always wanted to do, to be up front. So without being able to predict, I think the court would probably take a close look at the issue for the simple reason that, as I said before, this is a brand new ballgame. We have never been in an international situation quite as vexatious, quite as threatening, and quite as mysterious in a great many ways. I think the court will do well by the newspapers, which doesn't mean that they cannot occasionally be slapped down. Certain requirements are entire to see the light of day. So, thank you.
I guess I'd like somebody to talk about some of that, which is that is it enough to say that this is a new ball game? Barbara, you quoted earlier that one of the greatest defense of our liberties is the fact that we have access to information and that the public knows what's going on. And it seems to me, and I'm exposing my personal views on this particular case now, that closing deportation hearings, a blanket closing of deportation hearings, I get very nervous if the government's just saying to us, trust us, we have to have a blanket closing of all of these hearings, as opposed to making the decision. What's wrong with making those decisions on a case-by-case basis?
I would agree with you on that. Again, I think I would go back to the Hugo Black line about what's the option for the press and why does the press have this role in our democracy. But I would also accept Henry's point that this is a new era and we are in a situation that is unique to this country. I would be much more comfortable with a case-by-case approach to these issues.
My sense is, I guess I'd predict two things with confidence. One, the Supreme Court will take the issue. Second, they'll be split 5-4. And third, which is the 5 and which is the 4 will depend almost entirely on where Justice O'Connor comes out. But it is certainly true, as you point out, Josh, the issue is not whether a hearing is to be totally open or totally closed, but rather which way the presumption lies. And in lots of other sensitive proceedings, the Supreme Court has recognized a presumption of openness subject to selective closing based on special circumstances and needs, and a hearing in open court which establishes the basis for this selective closure with the understanding that when that need has been met or has passed, then the proceeding is open again. So I think there is a strong case for the presumption of openness, which is the way the Sixth Circuit decided in the Detroit case.
Well, now I'd like to open this up to questions from the audience. Yes, ma'am.
I read recently that at least in some libraries in California, there are now signs warning clients that their borrowing habits are being monitored by the government. Now, I don't know if that's exactly a violation of the First Amendment, but I mean, it seems that we should be free to take what books from the library we choose without having the government watching us in terms of that particular activity.
That you're specifically, that's Section 215 of the Patriot Act, and Catherine referred to it. Would anybody like to comment?
It's just a response to Section 215. Many of you are aware that Representative Bernie Sanders recently introduced legislation which would exempt libraries and booksellers from Section 215, presumably both from the susceptibility to demands for information and from the gag which Section 215 imposes. My sense is that those signs being put up in libraries are a way of garnering public support for the Sanders bill, which did have substantial bipartisan support when it was introduced in Congress, and certainly is moving forward.
Can I add a word to that, too? The what is it called? The Communitarian Association, the Communitarian Society in Washington, among others, did a poll about security issues, especially because the Patriot Act was passed within weeks of September 11th. And what they found was that as people feel more secure, their interest in their own liberties then increases, and vice versa. I gave talks in Virginia libraries in September, and part of these talks involved a discussion of the Patriot Act, which seemed to come as a surprise to many of the people in the audience, and in fact, even the librarians at some of the libraries hadn't yet developed a policy. Others, I noticed, were a little reluctant to talk to me, and it occurred to me later that possibly they had been enjoined to speak directly. However, some librarians did say that their libraries had a policy of, in fact, not keeping records when their patrons used the internet, for example. They didn't track where the patrons went. They didn't track who had signed in and then where they went on the web. And when a patron borrowed a book, that of course was kept on record, but once the book was returned, all record of the patron having taken out the book was expunged. I understand that Virginia libraries, at least when the Library Association met earlier this year or late last year, addressed this question and came up with a policy. The American Library Association has a terrific website that talks about this directly. So does the American Publishers Association of American Publishers, and a number of other associations directly involved with freedom of the press.
Yeah, the American Booksellers Foundation for Free Expression is a
yes.
third. It's really those three organizations working together.
Yeah, oh, I'm sorry, making you run all the way across. How about one right here, and then we'll come over this side.
Whenever I find myself succumbing to paranoia, I comfort myself with the truism that paranoids have enemies too. I think that this is the most repressive administration in my memory, and I go back pretty far. And what I find particularly ominous is that patriotism now is being joined at the hip with godliness. And I wonder whether anyone else on the panel shares this, this ominous, oppressive feeling that if you are not a patriot, ergo to wit, you're an atheist.
I just add that there has been some, less than I guess I would have liked, publicity to opposition from organized religious communities from the Vatican, which took a fairly strong stand, actually sent an emissary to Washington to make sure that the president understood where the Pope was on this imminent war, across the religious spectrum. And religious leaders have been quoted, although once the bombs start, that's another dimension that tends to get muted. So I think it bears watching. It does at times begin to sound almost like another crusade. I agree.
George, right here.
I'm curious about a point of law and about the distinction between disagreeing with a position of the government and supporting the troops. I'm going back to that question. If my memory is correct, and it could be very hazy, during the Vietnam War period, there were lawyers, there were people who advised soldiers in the military about what their rights were. Those particular people did not agree with the government position about Vietnam, and counseled people to actually be able to get out of service in some circumstances. That it's not clear to me that that's consistent with the earlier opinion I think Barbara mentioned, if I recall right. And I guess I've got two questions. Did the point of law change during that time? And a further question: if one disagreed with the government's position, what is your all's opinion about patriotism in terms of bringing that into, say, if you supported the troops in that way?
George, let me just add my perspective as part of the reason that I mentioned my having represented these three reservists. I think the downside of what some of us did in providing such guidance, certainly this is my recollection from California, was a kind of negative feeling or a negative implication about those in the armed forces who didn't tried to get some dispensation, who just went ahead and obeyed orders and went to Vietnam, putting themselves at great risk. I think a lot of what we were doing had a pejorative implication with respect to those who were not resistors or objectors. And that's what I wish somehow we could replay. Not that the law has changed, not that the policy has changed, but looking back, it seems to me that we were not suitably sympathetic to people who were drafted and were just doing what they were told to do.
And that's because many of the drafted, we weren't of the class. We used, in a certain way, collectively, the college student that I was, the group I belonged to, the college students, were not of the class who were being drafted. And I think we oughtn't forget that either.
Yes, sir.
I address this to each one of you. It seems to me obvious that the right of free speech requires an equal and an opposite right of free hearing or free reading. And the thing that disturbs me most about the Patriot Act and a lot of the other actions, particularly of this administration, is this closing down of our ability to get information, to know what's going on, to know what the government's doing. And my question is, how are we to participate in any form of democracy with a government that is based on black operations and hidden budgets?
Well, I'll take a quick shot at it. I think one answer is what the Senate did yesterday. To the amazement of people on both sides, 3 Republicans joined Russ Feingold and said we're going to take the probable cost of the war, at least $1 billion, out of the tax cut. That was done in a very open fashion. I also have great confidence in the news media. They are powerful. They exercise in our society, as each of my colleagues has said in a different way, both a responsibility and an authority. And to the extent that they feel that information has been withheld, they'll find some way to get it. It may take a while, but they'll get it. And I just have great confidence that important information cannot for a long period be withheld, whatever anybody in the White House or in either House of Congress may think.
And I have great confidence in the internet. So in addition to the media, and if we want to view that as new media, the litany that Catherine ran down of the sites that she goes to, the so-called blogs, Catherine's own online journal. So even I think if one accepts the premise that this government or this administration is closing down our access to governmental policy or governmental secrets, of course the ultimate irony is that the internet, unlike what Al Gore said, that he developed it and invented it, but of course that it was developed by the armed forces for time of war, and yet it has become probably the greatest tool for informing the public, presuming one has access to it, and that's a problem in many
It's very
instances.
interesting to read, say, an Iraqi blog who was from which you got information before you heard it, in fact, in our news. Let me add, too, I think this is terribly important. The political system still exists. The political process still exists. And it seems to me that along with our First Amendment rights and obligations is the general obligation to be as fully a citizen as we possibly can be.
And the fact that we're here on this beautiful sunny day discussing this issue gives me great hope.
We have time for one more question. I hate to make you run all the way to the back, but this gentleman in the back.
I think I can make myself heard. Mr. Neal was talking about his faith in the press to report on things, but I wanted to ask the panel, based on what we know about the concentration of the control of the media by major corporations increasingly as a trend, and the fact that a lot of the anti-war protests somehow just didn't show up in the media until quite lately. What do you all see as the consequence for the expression of dissent or in the expression of information if in fact the media are increasingly being controlled by the same corporate interests that are widely represented in the government?
Well, NPR has been covering continually since the war started, and they have a whole range of reporting. I listen to NPR rather than watch television because I don't have cable here. And I've been very impressed by their respect for all the different voices they listen to, the whole range of reporting and opinion they seek, and their regular coverage of all the dissent that is still going on in the country, as well as the rallying in support of the troops and possibly even in support of the war. I don't know if NPR is an example, although it could be exemplar in that sense. What I think is that because we have the means for openness, yes, the corporatism is always a worry, and more so, I think, as we go on rather than less. But the web, the internet, also put pressure on the other media to open. The enormous success of the peace movement as organized on the internet came late as news to the rest of the media. Now they understand it, and I think maybe the Congress is beginning to understand it. And so what I think is that the pressure for openness, in fact, is coming from the very medium that we use almost as intimately as we speak to each other. We use the internet almost that intimately. That will be the way that all the other media, I think, are kept open.
I'm afraid we've run out of time. I would just like to say a final point, which is that we all may disagree on the course of action that we are currently taking, whether we should be at war in Iraq or not. But one thing I hope everyone will agree with is that we all should have the right to express our opinions on that war and on any other subject. And with that final point, I'd like to ask you to join me in thanking our panelists for this discussion today. There are books. If anyone is interested in purchasing a book, you can probably prevail upon one of the authors to sign it.